Hello, and welcome to this webinar featuring Conscious Counsel, legal services company, brought to you by Massage Magazine Insurance Plus. I'm Karen Minahan, the editor of Massage Magazine, and today's presenter is Corey Sterling. Corey is a lawyer, small business owner, group fitness instructor, and yoga teacher. He teaches about the law in a fun and practical way. Corey and his team at Conscious Counsel have worked with Massage Magazine Insurance Plus to create specialized content, advice, and client intake forms for massage therapists. In today's webinar, Corey is going to discuss legal considerations related to running a massage practice right now, and he'll offer advice on best legal practices related to operating a business during the coronavirus pandemic and into the future. If you have any questions, please add them in the Q&A on your screen, not the chat. Use the Q&A area. Corey is joining us from Brazil, where it's night right now, so it's a little bit dark on his screen. Welcome, Corey.
Thank you. Thanks, Karen. Thanks so much for having me. It's great to be back with Massage Magazine Insurance Plus. So I know we had so much fun doing this the first time, so why not just double up the fun and keep the party going. And yes, thank you everyone who's watching for accepting the makeshift studio that I made here. I live in a beach town in Brazil, and it's nighttime, and you know, it's not like there's no places that are really inside here. So got my lamp and we're doing it. We're smiling. And I won't stop smiling no matter what.
Okay. So what are some of the considerations massage therapists should be aware of right now in terms of, legal considerations regarding running their practices?
The biggest sort of at Conscious Counsel, we sort of did a 2020 wrap up, and then we did a preview for 2021. And I think that the first thing that I said, or what I shared with my community going into this new year, is that the only thing we can really expect is the completely unexpected. So there's been so much variance and so much change, and it's such a unique time where things are changing so fast from a legal landscape, where governments don't really even have time to catch up with all of the considerations and changes that are happening, that I think that the most important thing is to keep a perspective about what you're doing, keep a perspective about the relationships that you have, and do your best in all of those relationships to act as reasonably as possible and to have the best legal support as possible, so that should an event come up or should an issue arise, you'll be in the strongest position to navigate from that challenging place. And I think if there's sort of one message that I would have for today, I think that would be it. I think firstly, there's not a panacea to resolving all of the legal issues in such a complex working environment that, whatever's happening is changing every day. But I think the important thing is taking a step back, remembering, okay, I can only control what I can control. And from a legal perspective, I'm going to be happy to walk through with everyone what are the different things that we can control from a legal perspective that can put us in the best position to operate safely.
Okay, that's great. I know one of the topics that you are planning to touch on today is teaching online, and everything people need to know as more and more massage therapists are kind of moving components of their practices onto Zoom or other online platforms. So would you like to dive into that first?
Yeah, sure. And I think also, firstly, everyone who's watching, hi, very nice to meet you. The goal of this talk really is to provide as much practical information as possible, and then as much value as I can to all of you. So be sure to ask questions. If there's anything I'm talking about that you're curious about, that you want to know more, please, this is the time to ask. I'm here for you. I want to help. I may not have a complete answer to every single question that you have, but I promise to share from the breadth of my experience. And in working with so many massage therapists and massage professionals, we see certain trends that are emerging. But I'm happy to sort of talk about the legal considerations first off, from teaching online and what it means. So teaching online, look, and I'm going to take one small step back before we get to teaching online, because I want to help change everyone's perspective about how we're looking at the law and how we assess what we need in any particular relationship that we're in. So basically, the law is a series of relationships that you have. And the goal in each of those relationships is to communicate openly and honestly, and to do so with written support. The reason why written support is so important is because as lawyers, it doesn't really matter what happens, it matters what you can prove. So in any legal relationship, two parties sign a document. Those are the promises that they make to keep in the relationship. And should an issue or event come up, we want to be able to consult that document to protect you and to make sure that you're covered. So, and this is like, I sort of want to walk everyone through this practical exercise so that you understand what my mindset is as a lawyer when I'm approaching something like this, because it's accessible to all of us and it's a lot of fun. And just like, hey, I promised everyone we were going to have fun today, so let's just do it. So when you think about the considerations of teaching online, the first question is, okay, who is this relationship with? So teaching online is a general statement, and there's a couple of different ways it could go. One way it could go is, okay, I have a space and I have other instructors who are also giving content and sharing information for my teaching online. That sort of like is either an independent contractor employee question, and then there's certain issues that need to be dealt with there. But most likely, if you are teaching online, the relationship is going to be with the student, right? That's what the word teaching would imply. So then the question is, what do you want to have and what do you need to have from a legal perspective in the relationship that you have with a student who is participating in an online course that you are making? And in the most simple, basic way possible to describe it, what's required is something that we call an online course agreement. So an online course, and just so everyone knows, to be super clear, an online course agreement was like a title that I just gave to this type of relationship because it's relatable to everyone, but I want it to make sense for you. So if you're leading a course online, these are the biggest things that you're going to have to do. You're going to have to like answer all the 5 W's and H question: who, what, where, when, how. Okay, how are the services provided? When are they provided? What is the, how much are you paying? What is going to actually be delivered? What expectations do we have of you in taking this? And just like think about creating any sort of relationship with anyone and addressing all of the important questions. Another thing about doing things online is that like you're not able to supervise directly what is being done. So you need to make sure that you have the appropriate language in there so that you're letting people know that like, hey, normally I would be able to correct you while we're doing this together in person, but while you're doing this course, I won't be able to. Another thing that just comes to mind that's really important and like a general rule for everyone to pay attention to, in all of your agreements, try your best to state your qualifications, especially if you're teaching. State your qualifications, what you learned, where you learned, what certifications you have, and what that enables you to teach. One of the biggest issues we see in the teaching area is someone who is not qualified leading a course and then people making complaints afterwards. So I hope that answers just as a general question. The first practice of teaching online is firstly understanding who the relationship is with. And if it's with a student, you're going to want them to sign a waiver of liability, and you're going to want to have, something like an online course or an online teaching agreement. And then, sorry, just one other point. If you are a business owner and you are recording other members of your team, be it contractors or employees, you're going to want to have something like a media release to make sure that you own the information. But I just want to pause and see, like, does that make sense? Does that resonate, what I'm saying?
It does to me. And we did have a question come in where someone's wondering if they need to copyright a copyright to protect their classes, products, and services when they're putting things online.
Yeah, so I'm happy to chat about copyright as well. So copyright is, just so everyone understands in a really simple high level approach, copyright is the protection of artistic works, right? So a video has copyright, songs have copyright, dances have copyright, things that you write have copyright. And the interesting thing about copyright is that it automatically exists once you create something, right? So like, let's say you do a dance, you do the Macarena. Is the Macarena still cool? Are people still doing the Macarena?
I don't know.
I'm still doing it. So if it's
And it's
if it's
cool.
cool, okay, wow, thank you. That's very nice. So, the way that copyright, the laws, your rights and what you create exists automatically once you finish it. So let's say, in terms of I'm teaching online, and I make a manual about the best massage tips for teaching online, as an example. The moment I save that document and I post it, I automatically have copyright in that. Copyright's tricky because it always comes down to being able to show who was the original creator of it and who created it first. So there is something that you can do both in the United States and Canada, where you can register a piece of work for copyright. So let's say you make a manual, you can register that for copyright. Let's say you write a blog post, or you come up with the program, or you create a method, or whatever it is, you can formally register that for copyright and receive a copyright certificate. The benefits of registering something for copyright, in addition to, showing the world like, hey, I made this and I have a copyright certificate, is that, let's say in the future, someone else wants to use your program, like you create a teacher training, and then, right, so you copyright the teacher training, and then someone else comes along and is like, oh, great, I'd love to use this and start my own teacher trainings. In that instance, because you have the copyright certificate, and like you've said to the world, this is my contribution, what I created, you can then go and license that. So when you have the best form of proof that you've created something and you're the author and you have the copyright, you could then license that off to other people and generate income from them using your intellectual property. I hope that resonates.
Yeah, thank you. We did have a question come in that kind of circles back to something you mentioned earlier, where you were talking about like having some agreements in place, like agreements with your students that you were teaching online.
Yeah.
Is there a place where you can point people to an example of how an agreement like that would be worded?
Unfortunately, I can't. It's a service that we offer with our law firm, so
Okay.
I don't have a general template, but I know that that Jake is posting a legal essentials. We have like a legal essentials checklist, which is a free gift for everyone, which we're happy for you to have. And that sort of breaks down the different relationships that you have, and sort of like what are the key issues. Because the interesting thing about the massage industry, and we see this a lot at Conscious Counsel, is that to each individual massage practitioner, the issues that are coming up seem really overwhelming and difficult to navigate, and like a solution is nowhere in sight. But for us as a law firm, because we're dealing with the same types of clients, always going through the same things, we sort of know what is required. So I know we worked really hard on the intake form that we shared, as well as the checklist. So I hope that's helpful. Yeah, I hope that's helpful.
Yeah, thank you for posting that checklist. And then I wanted to let everyone know that another thing being posted in the Q&A is a link to the Conscious Counsel webinar that took place in 2020, because we had several people who are eager to find that and watch that as well after this webinar.
Cool. It's just get some popcorn and learn about the law. Like, why would we not do that?
Really? So what's next up for us here? We could, yeah.
I think we should go to waivers of liability, just because waivers of liability are a very, very, very important document. And I don't remember what I said in the first webinar, but I'll try to like sort of take everything from a different approach if we have participants who were in the first webinar. But the reason why a waiver of liability is so important now is that, in addition to all of the standard reasons why we needed insurance and why we needed a waiver of liability before, obviously we're operating in a very unique climate where there are significant risks that arise from physical touch and contact. And so I think more than ever, what's really, really required and this is what I'm going to say before I get into the specifics of a waiver of liability, but I think it's also being really, really clear with your clients. And what I encourage everyone to do is, like, the whole point of this, like, sure, I can talk about the law and the elements of a waiver and whatever, but I want everyone to understand that most of the issues that you're going to run into normally can be avoided by communicating openly and honestly with your clients and just letting them know, like letting them know exactly what's up. Like, hey, you know, this is the situation. This is what's going on. I'd love to work with you. I want to help you, right? Some people are like, oh my God, no matter what, I need my massage, right? Does anyone know people that, yeah, I'm also that person where I'm just like, I just need my massage. But it's really, really important to make sure that in addition to having the written support that you just, you know, you see your clients and you let them know like, hey, these are the circumstances. This is the way that we're providing our services. And just having all of that down. Now, I think in addition to all of that, waivers now have to be much more specific than they were before. And what we've seen in drafting massage waivers specifically have been like, it used to be like, oh, it was just massage and it was in person and all the things. But now it's like we're building in all of the different possibilities of a different situation and where you could need to use it, because it's like everything was open, then everything was closed, and then some things were open, and then there were number restrictions, and then there were certain spaces we could do it, and there are things that we couldn't do it. And I think what's really important to remember in all of this as well, and this ties into waivers, but I just want everyone to get this concept. Please just get this concept. I think the biggest risk that we run, because there's so much uncertainty, the biggest risk that we run is acting negligently. And like negligence is a legal word, but it's also, you know, it's used in general. It's used on a day-to-day basis. But what I mean to say is like, the most important thing that we need to have is evidence and proof that we acted reasonably and that we weren't, you know, that we didn't disregard certain threats, or that we didn't, you know, that we considered all of the, you know, the potential dangers or things that could go wrong by doing something. Because I went through this period in 2020 where I was like, and I almost got the tattoo. I did not get the tattoo, but it's like agreements are storytelling, right? Agreements are storytelling.
Wait, Corey,
Yeah.
what's the tattoo? You have
No,
to tell.
that was it. I almost got it. It was going to be
Okay.
agreements are storytelling.
Gotcha. Thanks.
Because I was just like, it was like one of those, I was like a 2-week period of my life. I was like, oh my God, all of these documents, what we're doing is telling a story about, you know, our client who's a massage professional and has these different relationships. And then like, I was really hot on it for about 2 weeks, and now I'm coming back to it because it always comes back. But what I'm trying to say is like the risk we run is negligence. The risk we run is that there's a certain standard that a massage professional needs to behave in this uncertain climate. And the biggest exposure to risk that you really have is operating below that and something bad happening. Because the chances of something bad happening probably now are higher than they've ever been before. That's just the reality of what it is. So that being said, it's sort of like the bar has been raised. And now if we're going to be operating and we're going to be offering these services in this particular way, like you have to tell a story with your documents and you have to tell a story to your clients. And that story really should be like, hey, we considered all of the options. We told you all of the risks. We communicated all of this to you beforehand. And then, you know, you still decided to go forward with the services. And like, look, here's just an example of something that's super, super important to have. And it wouldn't go in a waiver, but I'll finish off waivers in a second. Explain to people the exact process of working together and have it in writing. And it's like, your temperature is going to be taken, you know, whatever specific things are most important for you to show that you're operating at best standards, and put that in an agreement so that in the event something happens, you're going to be able to story tell and explain to people like, hey, well, we did everything that we could, and we told you the process before, and you still decided to come, and you signed the waiver of liability, and in the service agreement, we explained the process. So like, okay, if you, the chances of an action succeeding with so much documentation and support is difficult. But lastly, to summarize waivers are super important because it's someone releasing you of liability for, you know, for receiving massage from you. And waivers have changed because now they need to cover so many more different types of circumstances than they did before. I hope that answers it. I hope that helps.
Yeah. It does sound then that a written waiver of liability is key beyond just the conversation with the client. Is that correct?
100%,
Okay.
1000%. It's
Yeah.
like a car without wheels.
Gotcha. Thank you.
Pleasure.
Yeah.
Does anyone have any questions?
So we don't have any questions about waiver yet, but we did have a question come in about regarding laws that might apply to virtual visits if a client is in a different state. So if I'm in California and I'm on Zoom and I'm teaching someone who's in Tennessee, are there any like cross-state types of laws and regulations that we need to be aware of?
It's so cool. I think it's such a cool question. Firstly, thank you to whoever asked it. I think it's such a cool question because, yeah, to me 6 months ago, it was so clear that this was going to happen, right? Like it used to be, we had our massage business and all of our clients or students were within a 7-mile radius of us. So we knew everyone and we were familiar with everyone, and all of that. And now what's happening is it's cool that like someone who lives in North Carolina can be practicing with someone who's California, whereas a year ago that never would have been the case. The first answer I'm going to give, Karen, I have a feeling you're going to love it. I have a feeling you're going to be really enthusiastic about it. The most important part of teaching someone in a different jurisdiction, it's the same thing as teaching someone in the same jurisdiction. And that's making sure that you have a good relationship with them. Because you have to think, okay, reverse engineering all of this. If a problem is going to arise, how will that problem arise? And the problem will only arise by whoever I'm teaching filing a complaint, being very upset, wanting a refund, whatever it is, right? So the first practice for everything that we're talking about, and what I hope everyone takes from this, is the importance of having good relationships with the people that you're working with, because that really circumvents all the problems. When it comes to jurisdiction, if you are allowed to decide in a legal agreement where the jurisdiction or arena for any, litigious behavior or any legal issues should take place. So for example, let's say I'm based in North Carolina. I have a client who's in California. I get them to sign a service agreement or a massage agreement or an online teaching agreement. And that agreement says like, hey, our business is based in North Carolina and we're offering the services from North Carolina. Therefore, any and all legal issues must be resolved in the jurisdiction of North Carolina. And
Okay.
that's like the most basic, simple answer I can give.
Mm-hmm. Great, thank you. We did have one question about waivers come in. Ashley asks, what if you work in a state where in court waivers don't hold water or just are not seen as valid?
So I wrote a book. Firstly, lovely question. I'm curious what state is being referred to. But I wrote a book called the Yoga Law Book. And in writing that book, I did a lot of research about waivers of liability in the health and the wellness stage area. And I was not able to find one jurisdiction where a waiver of liability outright did not apply. So in all of the research that I did, jurisdictions vary, whereas like, for example, in some jurisdictions, someone can sign away their right to bring an action if you act negligently or not. In other jurisdictions, they're like, nope, you can't contract out of negligence. Negligence being like, you made a really silly mistake. Some states will be like, okay, cool, we don't care if you make a silly mistake. Other states are like, no, silly mistakes will still apply. But at law, waivers of liability apply. The reasons why and when they don't, is when they're not properly drafted. So the general rule about a waiver of liability is that it will be acceptable to the point that it is drafted clearly and unambiguously. So that's why it's also really important that when you have your waiver that you specifically outline all of the activities that you're doing. So here's just one example where a waiver could or could not hold water. And I'd also love to know the origins of hold water. Do you have any idea, Karen?
Boy, I mean, it sounds like, probably something that's woven like a basket or a bucket and that doesn't leak, protects its contents. And I'm guessing that it seems like a pretty good guess.
Yeah, no, we'll take it. That's better than any guess that I've got. But so here's an example where a waiver would not hold water, and I'll explain why. So let's say I have a massage waiver, and all of it is for activities that are performed in person, nothing referring to online, right? Something happens, whatever, there's an incident, and the services were being performed online, right? In
Yeah.
that case, the waiver of liability likely would not hold, because any lawyer with, with 2 cents would say, okay, well, the waiver covers you for things that are done in person, but the waiver didn't cover you for things that are performed online. As such, whoever signed the waiver did not forfeit their rights to bring an action against you for something performed online. And in that case, the waiver would not hold water.
Okay. So, and when we're talking about a waiver of liability related to working with people in person in a massage session room, is there anything that should be in that waiver specifically related to COVID or coronavirus?
Yeah, for sure there should be. What should be included, generally speaking, is that you should include in the risks of the activity the fact there's a communicable disease that is going around, right? It's an added risk. It's not an added activity, but it's an added risk to doing something in person. So that must be mentioned. And as well, you'd want to say like, hey, there's also a risk that there's a communicable disease going around that we can't really trace exactly who or where, when has it. And that in the event that you contract it, I mean, look, it would be very difficult for someone to prove that they contracted it at a specific place, but they could certainly try. In the event that you do contract this communicable disease, you release us of any of liability because we told you that this was a risk before you did the in-person service.
Okay, thank you.
And just the other like cherry on top about that, again, comes back to the idea of acting reasonably. So, okay, we got you to sign the waiver, plus we were wearing masks, plus we sanitized our hands, plus we took your temperature. Again, storytelling.
Okay. And another waiver question came in. So let me just get the name here because I think that'd be nice to include. So Christine asks if you need to have the client sign this every time they come in, or if it's like a one-time thing.
No, so that's a very good question. And what happens is the general elements of a waiver of liability are the activities that are being done, the risks of those activities, the outcomes of the risks, and then there's voluntary participation, affirmation of health, and release of liability. So it's like, we told you exactly what we're doing, and we told you what the risks are, we told you what the outcome of the risk is. With all of that, you affirm that you're healthy enough, you affirm that you're voluntarily participating, and you release us of liability. In the waivers that we draft, we put in a particular provision which says like, it is your responsibility to inform us if anything changes, i.e. if you revoke your voluntary participation or if you're no longer healthy enough to participate. And that's important because so long as you are continuing to offer the same activities, then you don't need to change the waiver. But the moment that you bring in a new activity, or now you're doing things in person, or now you're doing things online, that's when you would need people to re-sign. But basically, the one time is fine so long as the activities all stay the same.
Okay, that makes perfect sense. Thank you. And
you're welcome. Can everyone just, are we having fun? Like, if you go in the chat and just give a thumbs up and be like, yeah, this is fun. I can't believe how fun this is. Anything with the word fun, I'm gonna rate the word fun. Yeah, I see a party emoji. Cool. Okay, so there's fun happening. This is good. Let's keep going. Let's roll it. I'm loving this.
Okay. So another concern that some massage therapists have, or questions that they have, has to do with trademarks and what a trademark is and what it protects.
Yeah. Cool. Okay, I'm so happy to share. So trademarks. Okay, I'm going to explain about trademarks. I'm also going to explain why trademarks was the bulk of the focus for our legal practice at the end of 2020. And the same way, and this is why I love the jurisdiction question, right? The same way that it used to be that I have, I've got my massage business in, I don't know where I am. I'm in Montana. I'm in Northview, Montana. If anyone's been there, I don't know. I just made it up. But right, so I've got my business here, and I'd say 80 to 90% of the people who come through the doors are local people. And maybe there's 10% of tourists who are coming in, but it used to be that we didn't really need to be as worried about trademarks because we knew most of the people around us, and that risk of someone seeing something online and then wanting to copy it was minimal. Like it wasn't as prevalent as it is today. But in the same way now that someone from North Carolina is working with someone in California, with social media, with our websites, with a change in consumer behavior to look for professionals in different jurisdictions, along what happens with that is people seeing other cool business names or cool trade names or cool slogans or cool logos. And they're just like, oh, I like that. Maybe I'll take that one. And that's why we saw a real influx of our clients registering their trademarks at the end of 2020. And I think it's a product of that. So that's like my little intro about what I've seen in terms of industry trends. So trademarks are really, really important if you have an existing business that you continue to use or continue to grow. And I'm going to explain why. So what a trademark is either a word or a series of words, like a slogan, or a logo with words. It can be any of those four things. And it is the thing that the world at large uses to recognize your business. And what you do is you register register a trademark for particular goods and services. So for example, Conscious Counsel, we're registered for providing legal services, offering online legal materials, and speak and leading and education seminars, right? As an example. So what that means is when I register that mark Conscious Counsel for those particular goods and services, I'm the only one who is allowed to use that in that particular way. The real benefits of registering a trademark, there's like three major benefits. And I've got so many stories about trademarks, but the three major benefits are: one, I have exclusive use. So that means I've registered Conscious Counsel. No one else is allowed to use Conscious Counsel in the goods and services same way that I use it. Number two, I have enforceable rights. That means that if someone else is using Conscious Counsel, I have the enforceable rights to send them a cease and desist letter, to start a legal action, to do whatever it is that I want to do to assert my rights and to ensure that that they stop, and I can protect my brand, and I'm the only one who's using my brand in that particular way. The third major benefit to registering a trademark is once you register a trademark, that's an asset to your business that if one day, if you want to sell your business, and I can tell you because I do due diligence in, valuations for companies when they're selling, having a registered trademark is a major bonus as an asset if someone wants to buy your goodwill. Conversely, if you're using a name that someone else has trademarked and everyone recognizes your business for the name that it has, the value of that sale will decrease significantly, just because who would buy a business that has a name with a trademark registered by someone else? But also you can the same thing about copywriting and coming up with a teacher training and licensing it out. When you have a trademark, you're able to license that mark out to a third party who's like, hey, I love your logo and I want to go to Fairhope, Alabama, real place, by the way, and I want to use that mark there. So then, okay, cool. You can use the trademark. Here's the trademark registration number, and here's a small licensing agreement about how you are allowed to use it in that particular context. So, sorry, go ahead.
Would that agreement normally also entail payment for the right to use the
For
trademark?
sure. That's like, look, I call it juice. Licensing agreements are my favorite things to work on because that's where it's like you're getting passive income from intellectual property that you invested in. So you'd say, okay, you can use it for 2 years, and then you can choose. It could be a flat fee, or it could be a percentage of revenue, or it could be a mixture, or it could be whatever it is. But and most of the stories that I was involved in 2020 around trademarks had to do with clients having a particular trade name that they would use, and then someone else came along and registered that before them. And even though they had been using the mark longer, because they were not the first one to register, they lost their priority and had lower priority in terms of who owns the mark. And I can tell you, challenging a trademark that's already registered, as opposed to just registering on your own, is like, it's 4 times more expensive, stressful, long, plus then the cost of registering the trademark itself. So
Okay.
does all that make sense?
It does. So Ashley asks how much, just in general, trademarking costs and if it's internationally recognized.
Okay, so the cost that we offer trademarks for is $15.88, and that includes all of the relevant searches and the registration itself. The prices went up January 1, 2021. If you were part of our mailing list, you had, chance to be part of a flash sale that we had. But the way that it works with trademarks in jurisdictions is that each jurisdiction has its own trademarks, but there are also treaties that exist between the different jurisdictions. So for example, Canada and US are 2 different jurisdictions, and often for clients, we'll register them in both. Europe is a completely separate jurisdiction. Australia is a different jurisdiction, and I've never done trademarks outside of any of those places. But they do have what they call treaties between them. And also, like, I just love doing my Austin Powers. I can't let go of the Austin Powers in me, just because he loved law also. There are certain treaties that the jurisdictions have where they will recognize a trademark registered in one jurisdiction, but then you have a certain period of time to register in that second jurisdiction. It's sort of like, if you want to take a nap, I could talk about trademark jurisdiction treaties and you'll be asleep in no time.
Okay, I'll call you if I have insomnia. We could talk about
Okay,
trademarks.
perfect.
So we have had a couple of questions about waivers of liability come in that I think are pretty important to address. Could we jump back to that for a second?
Yeah, let's do it. Waivers all the way.
Yeah. So a couple of people are wondering specifically about blood clots and deep vein thrombosis, which can be a symptom or a condition of COVID, and massage therapy can exacerbate that or, potentially dislodge a clot. And they're wondering if that's something that should be included, spelled out specifically on a waiver of liability.
For sure. I think the answer would be yes. And just for everyone who's listening, I think even that's a great example of Karen communicating something to me. And then, then if I continue to move forward with the treatment, now that's been brought to my attention, right? So that's the more specific you can be, the better. You don't look, if you really want a waiver of liability, that's 3 pages, you can have one. But I think it's that fine line of making sure that you can cover all of the relevant issues, all of the relevant risks. And like, for example, if blood clots and COVID are a risk of massage, then that should be included. And again, I just want, what I try to do so hard in these talks is just help everyone sort of like think like a lawyer. So the way that you want to reverse engineer everything is think about like, okay, what's the problem that's materialized? Something related to blood clot, and okay, what would be the defense to that? The defense would be, oh, well, we put it in the waiver of liability and we made you aware of that risk before you agreed to participate. And that's like, we just want to do that with all of the things.
And so is a massage therapist protected if there's a regulation in place where they are supposed to be wearing a mask in their session room as well as their clients, and they don't necessitate that? And then are they also covered if there's a lockdown in their area and they're practicing anyway?
I think that the answer to that, I can tell you I'm pretty sure without knowing, because it's just a hypothetical situation, which I'm sure happens quite a bit. But what I want you to consider is everything that I was saying about negligence and about storytelling. If something goes wrong for you and you were following all of the rules and you had all of the documents in place, for the most part, I don't see whoever's they're going to throw a case at you, but it's going to be difficult for them to make it. If something happens to them, to one of your clients, while you were breaking a governmental regulation or rule, that's the definition of negligence. So that's why I understand that it's such a challenging economic climate that, so many people are willing to do things because they need to continue working. So there's zero, it's all love. It's zero judgment for anyone who makes any decision, but just always keep these ideas of negligence and storytelling in mind. Because if I was a lawyer and masks were necessitated by, municipal regulation, and whoever was performing my massage did not follow that, I don't care about the waiver of liabilities out the door. There's a governmental rule that you didn't follow. It's so easy. It's so easy to show that you were negligent.
Okay, thank you. Yeah, it had to be said. Thanks.
No worries.
Yeah.
Should I keep rolling here?
Yeah, I mean, one of the things that we did think about covering today was talking about leases and lease negotiations.
Wow, you wanted to take. I feel like we were at a 10, and you just want to make it 11. Talking about leases.
Go for it.
Cool. Yeah, it's leases also sort of fall under that that umbrella. If you insomnia, we can talk. I can go very in depth about leases, but this is what I'll say about leases, and I'm really happy to speak about it because a bulk of my practice last year was working with clients who were trying to get out of leases, and then very, very rarely people signing new leases. And what I just want to say, if anyone's listening and if you're preparing to sign a new lease or find a new space, the rules of the game have changed. The rules of the game of leasing property has changed. And as such, you should not accept an old type of lease. You should not accept a lease that does not talk about things like lockdown or forgiveness or moratorium periods. All of that is part of the conversation right now. So please, if you're going to be signing something in the future, make sure that you address all of those issues because you deserve it. And what I'll say about landlords, generally speaking, the landlord-tenant relationship is probably the most difficult one of all of the different relationships that I coach my clients through. And just because typically there's the biggest power imbalance between the landlord and the tenants. If you're very lucky, you've got maybe mom and pop owners to the space, and they're, you grew up in the same town, they're lovely people, and they're willing to work with you to resolve something. But also, conversely, you often get big corporations that are just massive, big corporations that have a whole bunch of commercial leasing spaces, and they don't really care about you. So what I will say about leases just generally is that make sure that you review a lease before you sign it. That's please review your lease before you sign it. Just because often I'll have clients be like, oh, I was rushing to sign because I wanted to get it done before the time. So we just signed. And then I'm like, do you realize you just made all of these legal promises and so many of them are not in your favor? And on that point, the other thing that I always see in leases is that they are agreements that inherently favor a landlord over the tenants. It's they will put everything to favor the landlord because landlords are so used to tenants not challenging the document or not reading the document that it's just extremely unfair. So again, I think if there's a couple things to say, it's one, read through it. It's worth it. If you're getting a 5-year lease and whatever, you're paying $400 a month, it's worth getting someone to pay someone $300, $400 to review that document for you to make sure it's okay. B, understand that the environment has completely changed in the sense of you have to expect that you're going to be shut down, that the government won't let you be open, that you may not be able to pay the full rent, and bring those topics into the conversation to stand up for yourself.
Okay, thank you. I know that's going to be probably something of ongoing concern, just as things move forward.
I'm still waiting for government will catch up. Government will catch up in favor of tenants. It hasn't happened yet, but eventually it will happen.
So we're here at 5:45 Eastern time, but we have another kind of large area to cover, which is employer versus contractor agreements.
Yeah.
And the difference between an employee and an independent contractor. If you could touch on that, that's something always of interest to massage therapists.
For sure. I'm so happy to do that. So the big thing to understand is that, firstly, it doesn't matter what you call them. It doesn't matter if you get someone to sign an employment agreement. It doesn't matter if you get someone to sign a contractor agreement. What really matters is the way that the services are performed. And the reason why it's so important, that's the first distinction. Okay, how is this person performing their services? And once we see how they're performing their services, we understand if they're a contractor or an employee. And once they're a contractor or employee, then we understand exactly what the implications are and what different legal nuances should be addressed. So, for example, the way that you want to think about a contractor is someone who completely runs their own business. They have a particular skill set. They have, they run their own business. They have their own business cards. They have their own schedule. They have their own equipment. You are not allowed to tell them how to do their job. It's like the classic example is the plumber, like, right? When you're calling the plumber in, even if you're a business if you're a business and you have a plumber who comes to fix the toilet in the office, plumber brings the materials, you call the plumber comes when the plumber's able to come. You don't tell the plumber how to do their job, and like, that's their business, that's their service. Yes, you are paying them and they are working for you, but they are only providing those particular services and they have full control. Conversely, an employee is someone who works for you, and you have an employment agreement and an arrangement where that person is an employee. They are entitled to particular benefits from, state and federal benefits as a result of being an employee. And also, when you have an employee, you are allowed to control so much of the way the services are provided. So that the biggest difference of, I often hear clients say like, oh, well, why would I want an employee? And the answer is like, now more than ever, you probably want employees because you have very specific safety protocols and you have specific things that you're doing and you need things done a very specific way. And that's why you would have an employee. So the first question, like, I'm sure it's super relevant for everyone, but the first question is like, how are the services performed? And just so you know, in some states, it's more clear cut than others, but generally speaking, it always comes down to the control test. There are certain states like Massachusetts and California, where if someone is performing the same service that is the core service of your business, at law, they are an employee. In California, that was called the AB5 legislation. And then they came up with an amendment afterwards, which didn't really change things too much. But I just share the illustration that it'll be on a jurisdiction to jurisdiction basis. So either it'll be a place where they say, okay, all of the anyone who performs a service that is the main service of the business is an employee. In other jurisdictions, it will always be the control test, which is looking at a variety of factors about what makes scheduling, invoicing, equipment, business cards, uniform, ability to demand the services be done a certain way. Just off the top of my head, those are the specific criteria that will be assessed for the control test. And then I think just going to sort of that third level of, okay, like, why does it matter if they're an employee or if they're a contractor? Well, if you're an employer, if you have a business and you have employees, and those employees are creating intellectual property, i.e. they're recording courses, you're making videos of them doing things, so long as them creating that content is part of the scope of employment, all of those materials will belong to the business. Mm-hmm. However, if you have a contractor who's making videos, or you're filming a contractor who's providing content or helping for teacher training or something of the like, in that instance, the contractor also retains intellectual property rights. And I've seen stories firsthand that I've been involved with where a contractor contributed materials for teacher training, left the company, went away, 2 years came back, the teacher training totally blew up and got super popular. And they said, hey, you're using my teacher training manual. I'm entitled to part of the profits that you've made over the past 2 years. And that law, that was correct. So there are implications to making that decision. And it always comes down to the way the services are performed.
Mm-hmm. But that's a very interesting point, with the intellectual property and so much being done online now, and why an employee could be the way to go.
Yeah, it's all, look, it's also, the reason why working with the right lawyers is that there's easy ways to get around that. So you could have something like a media release signed, which basically says, even though you're a contractor, the business, in exchange for accepting the money, the business retains the intellectual property rights, the irrevocable rights to do with it whatever that we want.
Mhm.
But yes, but what I've seen more is that business owners need more control in such an unstable environment.
Okay, thanks. So wrapping up this webinar today, can you tell us what the top 3 legal essentials are that every wellness practitioner needs to ensure that they're protected right now?
The first thing is awesome written documents. Um, remember, please just like write this stuff down. It doesn't matter what happens, it matters what you're able to prove. And I'm adding this also to number 1 is like the importance of not being negligent. Like that's the first legal essential is, do not give anyone a reason to make an argument against you for being negligent in any way. The second most essential thing for massage professionals would be a very strong waiver of liability that covers you. And the blood clot example is perfect, like covers you for all of the specifics and make sure that you're covered for that. And the third legal essential would be, it's making sure all of your agreements are adapted for you operating online. So we didn't really touch on privacy policy and all of and those things, but I think just generally, like the essential modification that massage professionals, especially for an industry like massage that's so hands-on and traditionally has been so in person, have a look at the agreements that you have, make sure that they cover you for what you're doing online. The first thing I said is law is a series of relationships. And the reality for massage professionals is that all of our relationships have changed. And because they've changed, the expectations and the communication of those expectations have changed as well. So trying to be up to date with that would be super helpful.
Okay. I did want to let everyone know that we've put the link to the Conscious Counsel Massage Legal Checklist in the chat box on the webinar. I believe we'll be sending that out again as well. So Corey, if people have specific questions pertaining to their business, how can they connect with you?
Yeah, Jake is going to post something in the chat right now. What we always do is offer an opportunity for consultations. So if what I said resonated and you seriously you think that you'd like some of these services for either your agreements or a trademark or something like that, sign up. 10 minutes, we'll get to know each other, we'll have fun. It will probably be lighter out than it is right now. And you can tell me what's up and I'll be here to support you and try to get you to best practices.
Great. Well, I want to just say thank you from Massage Magazine and Massage Magazine Insurance Plus. On behalf of massage therapists who are here, thank you to all the attendees who are here. Thank you, Corey, Conscious Counsel. It's been great.
It's a pleasure. A big shout out to Jake, who works with us to make it happen. And now I'm even thinking about an MMIP tattoo. What do you think, Karen?
Go for it. Yeah.
Yeah. Well, you
I'll
guys
get one too.
matching tattoos. You want to do it
Am I really saying that in public?
on a recorded call?
Uh-oh.
I won't if you don't.
Okay.
Cool. Thank you for having me. Love everybody. Keep up the great work. Keep giving massages. The world needs massages and relaxing more than ever now. So keep up the awesome work.
Thank you.
Okay. Ciao. Bye, everyone.
Bye.